So let's go to the second question. Who has the legal right to inspect or copy corporate records? So we're using the same grammar. Whenever there is a right at law, there must be a corresponding legal duty. You can't have a duty without a right or a right without a duty. So if you have a right to inspect my records, then I have a legal duty to let you inspect them, and that will be enforced by a court of law. If it's a legal right, it means one which a court will enforce upon request. So we start with the assumption, or presumption if you will, that unless there is a statute or something somewhere that grants somebody the right to look at your papers, they don't have it. It's sort of like the default setting on your computer. When you turn the switch on, you get a blank blue screen. Well, in this area, unless the statute says that somebody has the right to come in and look at your books and records, they don't have that right. So if Joe Public walks in off the street and says, I want to see the minister's salary, you may politely advise them that they should have a nice day, but that's going to be without the benefit of the records they seek. So you start with the assumption that unless there is a specific legal basis for granting a right, then none exists. Okay, that said, where do we look to find if this right has been granted? First of all, you look in the Articles of Incorporation. If you write it in the Articles of Incorporation, you can grant your members or the public or anybody you want the right to come in and look at your papers. And I will tell you, most sets of articles do not contain that, but if you are faced with this situation and somebody other than me wrote your articles, you better go check them because it could be in there. Second, your bylaws and or constitution can grant people the right, the privilege to come in and look at your records. Again, we don't customarily put that language in there, but it could be. Third, you look at Arizona's nonprofit corporate tax code, and I have excerpted those important sections for you in this handout material. Finally, state or federal securities laws could contain requirements that you disclose if your church issues securities. Does anyone here, has their church issued a security that you know of? We won't go into that, but it is a situation where, for example, if you decided, like the Baptist Foundation did, to issue bonds, then you're issuing securities. And then you would become subject to a whole different set of disclosure regarding financial information. Finally, whoops, John.
Would an annuity with a member be security?
The question is an annuity issued by the church a security? And fortunately, the answer is no, because the annuity is specifically exempted under the securities laws. The final area where rights of disclosure can come forth is in a subpoena, which is essentially a court order, which someone has gone to a court, the court has agreed, at least initially, that this piece of paper should be delivered or served on you, requiring you to deliver material. And as you'll see in the policy material which follows, the quick and best answer is if you or any of your staff receive a subpoena, you should consult legal counsel, because there are grounds which you may want to assert for resisting the production of documents, even though that paper says you have to. Every subpoena is reviewable by the court if you challenge it in terms of its reasonableness of scope. Is it oppressive? Does it ask for privileged information? And if it does violate any of those rules, then you don't have to produce the information. But it's not your call. Only the court can quash the subpoena. If you don't respond to the subpoena, you can find yourself liable for civil penalties, including a bench warrant. And that means get arrested. You don't see that very often, but technically it is possible. Okay, so for the rest of our discussions today, we're going to assume that neither your charter nor your bylaws have addressed the topic of what you have to produce, and we're going to simply talk about what do you have to do under Arizona's corporate code. Well, the first thing you find is that members under Arizona's corporate code, if you have them, have a set of rights. Well, what's a member? And this is where I would point out to you, if you don't like the next part of this talk, see me afterwards and we'll help you amend them and get rid of the members. But if you do have members and they've been a member for 6 months, then they have certain rights to inspect your books and records. And if you turn to the next page under the third question, what inspection rights do members have, you can see that there's a specific checklist of requirements which the members must meet before they're entitled to look at your records. And by the way, we're now talking about, quote, corporate records. That's that list we rattled off at the first. First, they have to be a member of record for 6 months immediately preceding the demand. They have to specifically request one of the corporate records listed above. They have to inspect them only during regular business hours at the corporation's principal office. It must be made in good faith and for a proper purpose, and the records must be directly connected with the member's purpose. So, Monica, if you could stand up so the camera can pick you up here. What would you say would be a proper purpose for requesting a church's financial statement?
Well, a donor may want to determine whether it's an organization they want to contribute to, the financial health, the wherewithal of the company, how current their bills are, that type of thing. I could see maybe a donor would want to know.
What if I sit next to Mrs. Jones on Sunday in the pew and I just would really like to know how much Mrs. Jones gives?
Doesn't seem like a proper purpose, so yeah. Or IRS coincidentally has an exception too to their inspection records where if it's for a purpose that is harassment. So for example, you know, if a group decides, for example, to descend on Planned Parenthood and make 1,000 requests for their 990 just to harass them and destroy business, there is a provision for not providing those records if it's harassment or disruptive. So,
any specific questions about types of records or purposes that follow that point? If not, then do note that ARS section 10-11602E provides that the articles of corporation or bylaws organized primarily for a religious purpose may limit or abolish the right of a member under this section to inspect or copy any record. So if this becomes a problem, you do have a statutory remedy. And by the way, you may charge a reasonable fee for producing the records. The corporation may impose a reasonable charge covering the cost of labor and materials for copies of documents provided to a member, but the charge should not exceed the estimated cost of production or reproduction of the records. Now, another category of information that can become important is the membership list. If you think about the mechanics of the operation of our typical corporation for congregational meeting, in order to have a congregational meeting, you have to advise all the members that you're going to have it, right? And the law says if you don't give everybody proper notice as required by the statutes, then you didn't have a valid meeting. So to have a valid meeting, you have to have a valid list. So that means you have to have criteria for who's on the list and criteria for who's off the list. So somebody has got to keep the list current. That's really important when you start counting up the number of people on the list to determine what the quorum is. Because the law also says you can't have a valid vote if you don't meet the quorum requirements. So the list, if I were trying to make money suing churches, which I'm not, but if we were, the first thing I would do is get a pile of subpoenas and start subpoenaing membership records to see whether or not the congregational meetings comply. Because if they don't comply with a valid membership list, then none of the actions that they took at their congregational meetings are valid.
I have a question about that. When we keep our congregational meeting minutes, do we have to keep a copy of those members with that? Or can we just talk about the number of members?
The question was, when you do the minutes for your congregational meeting, do you have to keep an attachment of the list who attended? The answer is no. There's no statutory requirement that they be attached. There is a requirement, however, that you be able to produce that list if challenged. That means you should keep a permanent list. Those membership lists should be maintained on a permanent basis. So if you think about it for a minute, if you're concerned somehow or other about, about some group in the church being up to some chicanery, one of the things you might want to be able to do is get a copy of the membership list, send them information about what's going on. So the statutes provide a right for any member or member's attorney to get a copy of the membership list. And you can see, and I've given, we won't go through all the details of that list, or of how you get the list and when you have to do it, but it's all set out in your notes there. ARS section 10-11605 does limit the use of the membership list. You cannot use it for commercial purposes or to solicit money or property, etc. So you may prohibit the use of your church membership list for any commercial purposes.